Pas de... Qu'est-ce qui se passe? Bien, alors, permettez-moi de prendre la parole pour continuer maintenant cette conférence. Madame la ministre, monsieur le directeur, monsieur le professeur, chers Nicolas et Hassan, mesdames et messieurs. Permettez-moi donc de remercier chaleureusement tout d'abord tant le gouvernement du Luxembourg représenté par Madame la ministre de la Justice Elisabeth Marc que le Conseil de l'Europe qui a été représenté avant par Monsieur Gianluca Esposito, un directeur général, pour l'organisation et la participation à cette conférence qui concerne un sujet, et non des moindres, qui gîte au cœur de notre action. Nous le savons tous grâce à celui qui est la star incontestable de cette journée, l'arrêt Hornsby de 1997 et son fameux paragraphe 40 que l'exécution d'un jugement doit être considérée comme faisant partie intégrante du procès au sens de l'article 6 et de la Convention, sans quoi toute la construction du procès équitable serait illusoire. Alors j'ignore si après cet arrêt, les consorts Hornsby vécurent heureux et eurent beaucoup d'enfants, mais leur action juridique connut-elle une très nombreuse progéniture, comme nous illustrent les arrêts Bourdoff 1 et 2, Scondrino, plus récemment Bourmich, Camara, pour n'en citer qu'une poignée. Et c'est exactement ça le problème. En effet, le respect de l'état de droit exige celui des jugements par leur exécution scrupuleuse, prompte et spontanée. Il s'agit là d'une des exigences fondamentales pour le bon fonctionnement de l'institution en laquelle je siège, la Cour européenne des droits de l'homme, pour éviter en amont qu'elle ne soit engorgée et en aval garantir l'effectivité de son action. L'application des jugements nationaux est non seulement un droit pour chaque justiciable, mais la condition des principes fondant l'état de droit, sans lesquels l'action des juridictions devient vain. Notre système démocratique s'effondre et la subsidiarité, pourtant appelée de leur vœu par ceux-là même en charge souvent de l'exécution et qui y faillissent, devient inopérante. Sans exécution, il ne peut y avoir de subsidiarité. Pour en discuter aujourd'hui, nous avons parmi nous 3 invités de choix. Le juge docteur et professeur Niatowski, qui, outre son expérience extensive en droit international et humanitaire, a, en tant que juge élu à la Cour, une regrettablement vaste expertise du sujet qui nous chagrine, et qui va nous parler de la structure de la jurisprudence de la Cour en la matière, ainsi que de l'état actuel de ses vues sur la responsabilité partagée. La parole passera ensuite à M. Bakirci, qui, nonobstant son apparence juvénile, hante les travées de la Cour depuis le dernier millénaire et a, à ce titre, été un témoin privilégié de la submersion de la Cour par notre problématique, tout comme des mécanismes mis en œuvre pour juguler ce péril. Aujourd'hui greffier de la 2e section de la Cour, de laquelle fait partie la Turquie, le plus grand pays membre du Conseil sous maints aspects, il va nous exposer l'approche de la Cour confrontée à des problèmes systémiques de non-exécution. Le débat sera ensuite continué par le professeur Tridimas, docteur, barrister et directeur du Luxembourg Center for European Law, qui nous vient lui aussi d'un autre monde, puisqu'il fut déjà référendaire à la Cour de justice de l'Union européenne en des temps où le Royaume-Uni y eut un représentant. Tant praticien que théoricien, il évoquera pour nous le sujet sous son aspect communautaire. Chaque panéliste aura une dizaine de minutes avant que nous n'ouvrirons le débat à la salle et au monde pour des questions et un échange. Je passe désormais la parole à Nicolas Niatowski.
Thank you very much, dear Stefan. Dear Minister, ladies and gentlemen, dear colleagues, first of all, I would like to thank the Luxembourg Presidency of the Committee of Ministers of the Council of Europe for organizing this conference today, and also, of course, to the Department of the Execution of Judgments of the European Court of Human Rights, the Secretariat of the Committees of Ministers, for their engagement and for all the investments they've made into having this event happen today. As Judge Pisani has just mentioned, I happen to be a judge elected in respect of the country which has experienced the biggest difficulties, I can say it safely, in the Council of Europe area, precisely with the question of the execution of domestic judicial decisions. The famous pilot judgment, Yuri Nikolaevich Ivanov versus Ukraine, followed by the Grand Chamber judgment in Bulmich and others versus Ukraine, signifies the amplitude of the problem and highlights the issues that are really unique for the court and for our entire system of protecting human rights. My tasks today, though, will be to outline the approach of the court to the very question of the execution of final national judicial decisions. And I would also take this opportunity, as Judge Pisani has mentioned, to reflect a little bit on the ideology of this problem with respect to the overall function of the court vis-à-vis the domestic legal systems. And I'm very happy to be followed by Mr. Bakirci and by Professor Tridimas, who will also cover important aspects of the problem. And I understand that Mr. Bakirci will share with us his vast experience precisely with the issue that's been, I would say, haunting the system, and as well as Ukraine as a member state of the Council of Europe in terms of the systemic non-execution of domestic judgments. Let me start with a more general approach of the court, and then I will move to the question of the main principles that can be derived from our case law. Now, our convention is a very robust commitment to the protection and promotion of fundamental human rights and freedoms. And at the very core of this collective system of enforcement of human rights is the principle that there must be an effective remedy available for any perceived violation of human rights. This principle ensures that individuals are not left defenseless in the face of potential abuse by authorities, and this is indeed the cornerstone of the rule of law and democracy, democratic accountability, more specifically across Europe. Now, the critical feature of the convention system is its reliance on the principle of shared responsibility between domestic courts and the European Court of Human Rights in Strasbourg. This is founded on the principle of subsidiarity, which is now part of the preamble of our convention since the entry into force of Protocol 15. This assumes that the primary role in protecting human rights rests with the domestic courts and authorities, and the European Court only intervenes when domestic mechanisms fail to uphold the standards enshrined in the Convention. Now, it's clear that the domestic courts are the first line of defense in safeguarding human rights. And from this follows that the functioning of domestic courts, in accordance with the principles set out in the Convention, and first and foremost in Article 6 of the Convention, is indispensable to this system. Article 6 guarantees the right to a fair trial. And among other things, it ensures that individuals have access to justice, decisions are made by independent and impartial tribunals, and proceedings are conducted in a timely manner. The correct functioning of domestic courts forms the backbone of our convention framework. And one of the key aspects, as already mentioned today, by the Minister and also by Judge Pisani in his introduction, but also by Mr. Esposito in his welcome address, is the obligation to implement final binding judicial decisions promptly. And this is not merely a procedural obligation. It carries significant implications for the protection of human rights, because the failure to implement judicial decisions undermines the effectiveness of domestic courts and erodes the public trust in the legal system. It also has, obviously, the broader consequences that I have just mentioned for the principle of subsidiarity and the overall European approach to the protection of human rights. From the systemic perspective, the failure to promptly implement judicial decisions disrupts the balance of shared responsibility between domestic courts and the European Court of Human Rights. Of course, our court necessarily operates on the assumption that domestic courts are capable of addressing human rights violations effectively. And when this assumption is proven false due to the non-implementation of decisions, individuals are compelled to seek redress in Strasbourg. This doesn't only burden the European Court of Human Rights, but also signals a failure of the domestic system to fulfill its primary role. Consequently, the principle of subsidiarity is compromised, and the overall effectiveness of our system is called into question. Now, the case law of the court has already been referred to by the Minister, by Mr. Esposito, and by Judge Pisani, and indeed, Hornby versus Greece, a judgment adopted in 1997, even though this is not the first judgment on the subject, but still it enunciates the principles in the clearest way possible. And to be quite honest with you, the development of the case law since 1997 has not been so versatile, so to speak, as to describe it in granular detail at this stage, because essentially the principles are there. Our court has consistently reasoned that Article 6 secures to everyone the right to have any claim related to their civil rights and obligations brought before a court or tribunal. This embodies the right to court and the right to institute proceedings before courts constitutes one aspect of this right, but that right would be illusory if a contracting state's domestic legal system allowed a final binding judicial decision to remain inoperative to the detriment of one party. The court said that it would be inconceivable that Article 6, paragraph 1, would describe in detail procedural guarantees afforded to litigants, proceedings that are fair, public, and expeditious, without protecting the implementation of judicial decisions. To construe Article 6 as being concerned exclusively with access to a court and the conduct of proceedings would be likely to lead to situations incompatible with the principle of the rule of law. Execution of a judgment given by any court must therefore be regarded as an integral part of the trial for the purposes of Article 6. Since then, the court has developed a number of principles. I will try to summarize them and to group them but into certain parts. But in fact, I think they are very consistent and extremely easy to understand. And Mr. Esposito alluded to this in his opening remarks. So it all starts with the idea that execution of judgments must be full and exhaustive, not just partial, and must not be prevented, invalidated, or unduly delayed. A litigant may not be deprived of the benefit within a reasonable time of a final decision awarding him compensation for damage or housing, regardless of the complexity of the domestic enforcement procedure or of the state budgetary system. Here comes the idea that is absolutely crucial, and for my country, Ukraine, I think it should be written, I wouldn't say in gold letters because that would require money, but in big, bold letters, everywhere and on every document which tries to address the problems identified by the court in Ivanov and Boehme judgments. Namely, I quote, "It is not open to a state authority to cite lack of funds or other resources as an excuse for not honoring a judgment debt." And this is essential. Then, of course, we have case law concerning the unreasonably long delays in enforcement of binding judgments, and then there's different scenarios where the court judged that the delay is not justified or it is justified based on the circumstances of the case. For example, there is a rule of thumb of 1 year for financial obligations, for financial debts. Then there is a group of case law which deals with debts by private parties and the positive obligation of the government to put in place a system which would ensure the execution of domestic judgments in the disputes between private parties. Then there is an emphasis in the court's case law on the administrative proceedings, saying that it is all the more important for the authorities to deliver on the judgments when it comes to the questioning of their administrative decisions. Then there is case law which deals with the question of how active the applicant is expected to be in seeking the implementation of the finding of the final domestic judgment in his favor. And there again, there is the principle of basically reasonableness in requiring this active participation from the claimant, from our potential litigant, and altogether. There is an aspect which deals with the local authorities, for example, that the local authorities do not enjoy the autonomy that would free them from the obligation to execute the judgments and so forth. So essentially, these bits and pieces of the case law, they fit very clearly into the one simple idea: the obligation to ensure effective and timely enforcement of judgments, balancing the responsibilities between state and private parties while upholding the provisions of Article 6, Paragraph 1 of the Convention. To conclude, and anticipating my colleagues' interventions and further subsequent discussions, I would like to say that it is clear, not only from the Ukrainian experience, but also from the experience of a few other member states of the Council of Europe, that the only solution is concerted action within the government, within the state authorities, including the government, the legislature, and the courts, in order to ensure that the legal system functions. And the legal system will only be functional if final domestic judgments are implemented. Thank you very much for your attention.
Merci Nicolas. Alors maintenant la parole passe à Hassan Bakirci.
Many thanks, Stefan. Madam Minister, distinguished judges, dear colleagues, ladies and gentlemen, good morning. Allow me to begin by expressing my gratitude to the organizers of this important conference, particularly permanent representation of Luxembourg and the Execution of Judgments Department, for the invitation to participate in such a vital discussion on the enforcement of the national court decisions. It is a privilege to contribute to this very important dialogue. Judge Pisani and Judge Natowski have outlined the fundamental principles of the rule of law, access to court, and the evolution of the court's jurisprudence on the non-enforcement of domestic decisions, tracing its development from the landmark Hornsby versus Greece judgment in 1997. Building on Judge Natowski's insights, I wish to talk about the court's case law and practice in addressing the pervasive problem of non-enforcement of domestic decisions caused by particularly systemic and structural shortcomings in the member states. My analysis will unfold in two parts. First, I wish to highlight some of the court's pilot judgments and the principles which it applies in cases concerning non-enforcement of domestic decisions. Then I will turn to the pivotal, some might say infamous or notorious, judgment in the Burmich case against Ukraine, reflecting on the important lessons to be drawn from this experience. So on to my first point. The court has been dealing with mass litigation resulting from structural or systemic problems in the contracting states for almost 3 decades now. These structural or systemic problems cover a wide range of issues, including non-enforcement or delayed enforcement of domestic decisions, and lead to a growing number of applications being brought to the European Court. To illustrate this phenomenon, I wish to point out that between 1999, in the aftermath of the Hornsby judgment, and to the present day, the court has received approximately 57,400 applications concerning only non-enforcement of domestic decisions. These applications have been brought primarily against Ukraine, as Judge Natowski have pointed out, with some 29,000 applications. Then countries like Serbia, Russia, Moldova, and Italy also have received a significant number of applications. As many of you already know, since its Broniowski judgment in 2004, the court employs the pilot judgment procedure when it identifies a systemic or structural issue in a contracting state that has led to a large number of repetitive applications before the court. The procedure aims to provide a comprehensive solution to widespread human rights violations rather than addressing each case individually. In this context, the court has delivered several key pilot or quasi-pilot judgments to address this big influx of cases concerning the non-enforcement of domestic decisions. These judgments establish the legal problems and root causes of the structural and systemic issues which generate large number of cases coming to the court and direct contracting states to adopt general measures to remedy systemic dysfunctions in national law. If I may illustrate with few examples, in Burdov number 2 against Russia, a Chernobyl rescue worker repeatedly complained about non-enforcement of favorable domestic decisions. Yet the authorities failed to enforce these rulings, reflecting a widespread problem impacting pensioners and other persons. Similarly, in Yuri Nikolaevich Ivanov case against Ukraine, the applicant had obtained a final domestic decision awarding him unpaid pension arrears, but the Ukrainian authorities again failed to implement the court decisions. In Olaru and others against Moldova, the applicants faced years of inaction by the authorities despite court orders granting them social housing, exposing yet another structural deficiency in the member state. Likewise, in Manishakya Puto and others versus Albania, the applicants, heirs of expropriated property owners, struggled with the authorities' prolonged failure to enforce final judgments recognizing their property rights. Finally, in Kachapor and others versus Serbia, the applicants, former employees of socially owned companies, complained about the authorities' failure to enforce final judgments awarding them unpaid salaries and employment-related benefits. In all these cases, the court found that the root causes of these structural and systemic problems were essentially lack of financial resources, complex or inefficient administrative procedures, and lack of political will to address social or economic issues. In these cases, the court did find violations of the applicant's rights under Article 6 and 13 of the Convention and Article 1 of Protocol number 1. Finally, under Article 46, the court required respondent states to adopt general measures to provide redress to all victims and eliminate the root causes of the systemic problem, which continue to generate numerous applications before the court. In these pilot judgments and many other individual cases, the court has established 5 key principles, which Judge Natowski have already pointed out. But very briefly, the court said enforcement is an integral part of the right to a fair trial under Article 6. States cannot justify non-enforcement by invoking financial or administrative difficulties. Thirdly, timely enforcement is essential. Delays should only be permitted in exceptional circumstances. 4, non-enforcement of a court judgment within a reasonable time constitutes an interference with the right to peaceful enjoyment of possessions under Article 1 of Protocol number 1. And finally, states must provide individual and general remedies, and they are required to provide compensation to affected individuals and implement reforms to eliminate the root causes of the systemic and structural problems. Having said that, some of these pilot judgments have been successfully implemented by the respondent states. Some have been partially executed, but one of them has completely failed, as the respondent state was unable to carry out the necessary reforms. That is the pilot judgment in the case of Ivanov versus Ukraine, which Judge Natowski have pointed out. So on to my second point. The failure of the pilot judgment procedure in the Ivanov case led the court to adopt a groundbreaking judgment in the case of Burmich versus Ukraine. In a nutshell, the Burmich judgment, in the Burmich judgment, the court held that the legal issues surrounding the prolonged non-enforcement of domestic decisions had already been resolved in the pilot Ivanov judgment. The court considered that it had fulfilled its mandate under Article 19 of the Convention by identifying the systemic problem, finding a violation of the Convention, and providing clear guidance on the general measures to be adopted under Article 46 of the Convention. However, in the years following Ivanov, from 2009 onwards, the Ukrainian authorities failed to implement the necessary measures. Faced with a growing backlog of similar cases against Ukraine, the court considered that continuing to examine these cases individually would not resolve the underlying problem. It therefore decided to join all pending and future similar applications, strike them out from its list of cases, and transfer them to the Committee of Ministers, which is responsible for overseeing the execution of judgments. Yet in this judgment, the court added a safeguard clause, noting that it may restore these applications to its list if the circumstances so justify. However, to date, the court did not activate this clause for various reasons. Obviously, this judgment in Burmich met with strong criticism, both from within and outside the court. However, the key question remained: how did we reach this point? I think the answer lies in the failure of the respondent state to adopt effective general measures. When the Ivanov judgment was delivered in 2009, the court gave Ukraine 1 year to establish an effective domestic remedy capable of providing redress for the non-enforcement of domestic decisions. It made clear that if Ukraine failed to act, the court would have no choice but to resume examining similar applications. At the relevant time, the court had already adjourned examination of some 1,400 pending cases to allow time for creation of a remedy in domestic law. The Ukrainian government was granted an extension, but ultimately failed to deliver the necessary reforms. By then, the number of pending cases before the court had surged to 2,500. Given this failure, the court resumed its examination of these follow-up applications. To manage the growing caseload, the court introduced the fast-track procedure and IT tools to process these cases more efficiently. In July 2012, it delivered its first group judgment in Haruk and 115 other applications. However, these efforts, the court's backlog continued to grow. By the time Burmich judgment was decided on 12th of October 2017, the court had already examined and disposed of 14,430 Ivanov-type cases. Yet 12,143 of them were still pending before the court. In other words, the court's efficiency in the case of Ukraine backfired. The more cases the court processed and examined, the more applications it received from the applicants in Ukraine. As the court itself observed in Burmich, this situation created the risk of the court becoming part of Ukraine's non-enforcement system, effectively substituting itself for the national authorities. This, of course, was incompatible with the court's subsidiary role under the Convention. The Ivanov and Burmich cases serve as stark reminders of what happens when contracting states do not execute the court's judgments. No matter how efficiently the court delivers individual justice, if systemic problems remain unresolved at the national level, the long-term effectiveness of the convention system is put at risk. This is why execution of judgments is not just a legal obligation. It is an essential pillar of the convention system. Finally, a key takeaway from the Ukrainian experience in the Ivanov and Burmich cases is the crucial role of cooperation between the court, the respondent state, and the Committee of Ministers. Without thorough groundwork before issuing a pilot judgment, its implementation is likely to fail. So to conclude, the execution of domestic decisions is not only a fundamental aspect of the rule of law, but also an essential component of the right to a fair trial under Article 6 of the Convention. In particular, a judgment that remains unenforced means justice denied, undermining trust in the judiciary and the effectiveness of legal protection. As seen in Burmich, when national authorities failed to implement necessary reforms, repetitive cases overwhelmed the court, threatening the long-term effectiveness of the convention system. The responsibility to uphold human rights and the rule of law cannot rest solely with the European Court. It must be met with genuine commitment by the contracting states and effective oversight by the Committee of Ministers. The convention system can only function if judgments, whether domestic or from the court, are fully implemented. Without this, legal rights remain theoretical, and the convention's promise of justice remains unfulfilled. Thank you very much for your attention.
Merci Hassan Bakerchi, et la parole est maintenant à Monsieur le professeur Tridimas.
Thank you very much, dear Minister, dear judges, ladies and gentlemen. Thank you very much for this invitation. It is an honor to be here, and I feel very privileged. And I'm here with a great pleasure, and also given the audience and the co-panelists with some trepidation. I was going to structure my comments under the following headings. First, say a few words about the importance of enforcement of judgments. Secondly, look a bit at how European Union law treats the enforcement of judgments of the Court of Justice of the European Union. Thirdly, look a bit at the relationship between EU values and the enforcement of judgments. And finally, one word about the regulation on the rule of law conditionality. So first topic, the importance of enforcement. It's become clear, I think, from what the previous speaker said, that enforcement of judicial decisions is not a luxury, it is a necessity. And to my mind, it is important for 4 reasons. First, it is an attribute of the rule of law. Secondly, it is dictated by the principle of equality before the law. Thirdly, it is a consequent of the separation of powers. And fourthly, it is an integral part of the right to judicial protection. The rule of law forms the cornerstone of liberal democracies, and essentially what it means in its bare minimum is that both public and private power must be exercised in accordance with the law. This is the definition which is given, for example, in the a Charter of Fundamental Constitutional Principles of a European Democracy that was issued by the European Law Institute. So if the law is to be observed, that means that judgments which apply the law to specific facts must also be obeyed. So even if one were to follow a purely procedural understanding of the rule of law, enforcement with court decisions is an integral part of it. And this, of course, applies both to judgments against public authorities and to judgments against private parties. It is also an attribute of equality before the law. It's notable, I think, to recall here a report of the Security Council of the United Nations going back to 2004, where the UN Secretary General Kofi Annan provided a definition of the rule of law. It said the rule of law is at the heart of the mission of the United Nations, and defined it as a principle of governance in which all persons and institutions public and private, including the state, are accountable to laws that are publicly promulgated, equally enforced, and independently adjudicated. So equal enforcement of the laws also includes equality in the observance of judicial decisions. And this is also a consequence of the separation of powers. Each branch of government must respect the powers and the decisions of the other. So the executive must respect the judgments of the judiciary. And finally, of course, it is an integral part of the right to judicial protection. I think previous speakers explained that much better than I could do. There were references to the case law like of this court, like Hornsby and Greece. The European Court of Human Rights has made it clear that states have a positive obligation to organize a system for the enforcement of final judgments in disputes, not only between the individual and the public authorities, but also in disputes among individuals. So let me pass to the second theme. How does EU law view this? Now, for European Union states, I think there is, if you wish, a triple obligation. They need to comply with judgments of the European Court of Justice. They need to comply with national judgments. They also need to comply with judgments of the Strasbourg Court. The obligation to comply with the judgments of the Court of Justice of the European Union derives from two things: from the primacy of EU law. In case of conflict, EU law takes precedence over the law of the member states. So first, primacy is a legal base for the need to comply with the court's judgments. And secondly, the so-called duty of loyalty or cooperation. This is found in Article 4, Paragraph 3 of the Treaty on European Union, and essentially commands member states to take all appropriate measures to ensure fulfillment of their obligations arising from the EU treaties. And I think according to the case law of the Court of Justice, national courts have the obligation to provide for full and effective protection of EU rights. And I think the role of national courts is particularly important because European Union law is based on rules. It is the edifice of European integration is based on rules and institutions. It is the law that holds the system together. Just one word about the mechanics of this. The Court of Justice delivers preliminary reference rulings when a national court asks the Court of Justice for a question on the interpretation or the validity of EU law. The national court has to comply with the judgment of the Court of Justice. And according to the case law of the Court of Justice, especially a case called Kobler, a member state may be liable in damages to a person for loss that person suffers as a result of the national judiciary to comply with EU law. So there is a right to reparation against the state which extends to acts of the national judiciary. The Commission can also bring proceedings against the member state for its failure to enforce EU law. And if these proceedings are successful, the Court of Justice issues a declaratory judgment finding the state to be in breach of its obligations under Article 258 of the Treaty on the Functioning of the European Union. And if the member state then fails to comply with the judgment of the court, there is a possibility of the Commission seeking the imposition of a fine, financial sanctions. And the fine is has two components. It's a lump sum and a periodic penalty payment for every day that the state fails to comply with this second judgment of the Court of Justice. The Commission has issued detailed guidelines on the calculation of the fine, and essentially the factors that are taken into account are the ability of the member state to pay, depending on its GDP, the importance of the state in the EU, depending on which is calculated by reference to its voting rights in the Council, the seriousness of the violation, and also the duration of the violation. Allow me to go to the third theme, the relationship between enforcement of judgments and EU values. So my claim here is the following. The Court of Justice of the European Union has interpreted Article 19, paragraph 1 of the Treaty on European Union as imposing systemic obligations on the member states. Article 19, paragraph 1 states that member states must provide remedies sufficient for the protection to ensure effective legal protection in the fields covered by union law. So it is a provision which appears innocuous. It imposes an obligation on member states to provide sufficient remedies. But the Court of Justice has interpreted this provision in combination with Article 2 of the Treaty on European Union, which provides for the values of the EU, and these values include the rule of law, so as to impose obligations on the member states on how to structure their judicial systems. So the court has held that judicial independence is a necessary attribute of the rule of law. Unless national courts are independent, then they cannot provide effective protection of EU rights. Because essentially every national court is also an EU court. It applies EU law. Potentially every national court may be asked to apply EU law. So all national courts need to be independent. It seems to me that by the same token, to comply with Article 19, paragraph 1 of the Treaty on European Union and Article 2 on the values, a member state must structure its legal system, its judicial system in such a way as to ensure effective enforcement of judgments. State laws or practices which systematically make it impossible in practice to enforce a judgment appear to me to fall short of the requirements of Article 19 in combination with Article 2. There is no specific case law on this, but to my mind, just as judicial independence is an integral part of a well-functioning system and a sine qua non for complying with Article 19, so is a compliance with judgments. The need to comply with judgments is also made clear in the rule of law conditionality regulation. This is a regulation which was adopted as part of a series of measures following COVID and essentially makes a link between the obligation to comply with the rule of law and the obligation to on the member states to provide for effective remedies to avoid fraud on the community budget. And if there are systemic or persistent failures of the rule of law, which may have an influence on the EU budget, then the European Commission may impose certain sanctions against member states. And one of the attributes of the rule of law there is effective enforcement with judgments. Now, final point is that in the context of the European Union, one can have the opposite. In other words, member states must not only ensure effective enforcement of judicial decisions, but also there are provisions to ensure that national judgments that fail to comply with EU law or national decisions, administrative decisions that fail to comply with EU law, remain unenforceable. This is the reverse situation, and some interesting case law has developed also there. In a nutshell, I think, as I said earlier, effective enforcement is not a luxury. It is not something that is one more obligation that can push down the line or made subject to structural difficulties. I think it is a sine qua non for the administration of justice and the continuing observation of fundamental rights. Thank you very much.
Alors, je remercie le professeur Tridimas pour cet exposé très enrichissant sur les principes qui gouvernent l'application des jugements nationaux dans le droit de l'Union européenne. Et je vais désormais donner la parole à la salle, mais également au monde qui nous suit online, pour permettre de poser des questions ou d'élargir le débat aux considérations qui les animent. Donc tout d'abord, y aurait-il une question dans la salle pour rebondir sur les propos tenus à l'instant ? Nous avons un volontaire.
Yeah, thank you very much. I would like to ask the question to Mr. Hassan Bakirci. So he mentioned the fact about the Bournemouth judgment that the court may want to restore the cases in its list. So can you, like, hypothetically imagine what kind of reasons may be for the court to restore all these cases of Bournemouth in its list? Thank you.
Many thanks for this question. Indeed, it's one of the controversial paragraphs of the Bournemouth judgment, notably paragraph 223, if I'm not mistaken. The court said, and I paraphrase, that if the circumstances so justify, it may restore. So it didn't say it will, but it may restore all those applications in case the respondent state, again, fails to carry out necessary reforms under the supervision of the Committee of Ministers. Obviously, since 2017, many things happened, and I know that in cooperation with the Execution Department and also the Committee of Ministers, Ukrainian authorities did take some measures, but in 2022, unfortunately, the war followed. So we are now unable to say what will happen to the execution of the Ivanov and the Bournemouth judgment. So I'm really unable to predict the outcome of this clause, which the court inserted in its judgment. It was a safeguard clause under Article 37, paragraph 2 of the Convention, but it never materialized so far. It is one of the questions which is open for debate.
S'il vous plaît, prenez la parole.
Well, thank you very much for the invitation. We all agree on the importance of enforcing the court decisions, but however, my question is whether there is a solution to mitigate the impact on the judicial system. I would like to make a concrete example. After the Torgiani decision in my country, Italy, the remedies of 35 bis and 35 ter were introduced, and I came from a very small court that deals with the execution of criminal sentences for high security prisons and 41 bis special regime prisoners, and there are 6,500 compliance more or less in 1 year. And you can imagine also in all Italy what is the impact of these new remedies, and maybe also because there are some structural problems in Italy. So my question is if there is a judicial remedy to mitigate the impact on the administration of justice when there is a structural problem in a country. Thank you so much.
Alors, the question, is it addressed to any particular member of the panel which you would like to take a position on? So the difficulty of national courts to execute. So maybe Professor Gniatowski would be the best suited.
Yes, thank you very much. Thank you very much for the question. Well, it's true that the question of non-enforcement is very multifaceted, and it's not. For example, for Ukraine, the vast majority, not all of them, but the vast majority of situations stems from the fact that a state establishes certain payments, usually within a social system, without actually being able to pay the bill, to be honest. Whereas in the example that you've given, it's a very different sort of facet of it. But of course, it all comes down to the same principle that the judgments must be enforced, because we can certainly envisage compensation mechanisms. One can always try and create a kind of a net to intercept possible applications to Strasbourg by creating a domestic remedy whereby persons would be, let's say, awarded non-pecuniary damage for the non-execution. But that does not solve the underlying issue of the need to execute the judgment. And to me, this resembles very much the foundational problem that our system, meaning in the broader sense, not only of the court as such and the convention, but also the Council of Europe as such, always faces. Namely, is there a willingness to engage? Is there a willingness to cooperate? Is there a willingness to finally solve the issues without finding excuses or ways to, let's say, to block them from appearing in Strasbourg before the Strasbourg court? So, for me, this is absolutely foundational. And to reflect a little bit, I'll take this opportunity on the previous question of restoration of cases, as Mr. Bakirci has mentioned, that this is certainly something that is highly debatable in the literature, but of course it can be debated also within the court. But ultimately, this boils down to the question of whether there is a call to set in motion a procedure envisaged by Article 46, Paragraph 4 of the Convention, or not. Because ultimately this is all about the willingness to engage and the ability to cooperate. And I think this covers the problems highlighted in both questions. Thank you.
So I hope this answered the question to some regard. I must say, this seems to be an issue that lots of our intervenants think about. Also online, we have a question which is not so distant from what we just said. It comes from the head of the Prosecutor Training Center of Ukraine, Mr. or Mrs. Olivia Ochtanova, says, is there any balance between the state budgetary constraints, lack of financial resources, and its obligation to ensure the effective execution of judgments? Are there any best practices how states solve the problem of the lack of finances? So as regards the best practices, now I could turn the question again back to Judge Gniatowski, but I would like to avoid to put him in an embarrassing situation where as a judge he would have to take a position of an issue he might be seized with. So maybe we could turn this question to Hasan Bakirci.
Thank you very much, Judge Pisani. Indeed, when we were dealing with the phenomenon of non-enforcement of domestic decisions regarding Ukraine, my colleague Pavlo Pushkar and I had visited Ukraine in 2014. What we noticed by then was there were some 250,000 cases where the state debt had not been paid to the claimants because there was a moratorium on the state debt at the relevant time. So when we digged in, the real problem, it was essentially lack of funds in the Ukrainian state budget. And Ukraine, when I was studying this problem at the time, I had read an article where it said that since the Soviet times, Ukrainian authorities had introduced a number of social benefits, such as the victims of Chernobyl catastrophe or victims of the Second World War, many benefits. When you added up all those benefits, they were bigger than the state budget itself. So obviously, when somebody, a claimant, goes to domestic courts, asks for that, asks for her pension, for instance, or social benefit to be paid, the domestic court awards the compensation. But when there is no money, what can the authorities do? And there is nothing else to be done. One good example, actually, it's not about the availability of funds, but we did have some cases against my own country, Turkey. And Turkey, in order to deal with systemic and structural problems, they did set up a compensation commission in Turkey, so which allowed us to repatriate many repetitive applications, including non-enforcement of domestic decisions, so that people who had cases pending before the court or people who had cases in Turkey could turn to the Compensation Commission and obtain compensation for non-enforcement or delayed enforcement of domestic decisions. We did recommend this structure to the Ukrainian authorities, but again, it boiled down to the lack of funds because Ukrainian authorities were unable to pay thousands or maybe millions of claimants in domestic law. Thank you.
Est-ce qu'il y a d'autres questions dans la salle à ce stade? Alors, si tel n'est pas le cas, je vais me... Ah, il y en a une, bah, c'est super. Voilà.
We've been, well, generally you have maybe one decision and one person to enforce or to respond for that enforcement. But we had the recent decision of Klima Seniorinnen against Switzerland, where the question of, well, the claim was made that the state Switzerland was not doing enough to avoid the consequences of climate change. Now, enforce that when actually it is the parliament or the legislator sections that are under scrutiny or that would need to be examined if they were enough to fulfill the obligations under that decision. So I think my question would probably go to Judge Gnatowski. How do you reconcile that with the separation of powers, that one power puts the actions of a different power, of the legislative branch, under scrutiny, under the terms of implementation of a specific decision, as it happens in that specific decision?
Do you, Mikola?
Yes, thank you very much for the question. I must admit this is not so directly related to the topic of today's gathering, in my view, but just to say that, of course, I cannot preempt whatever discussions the Committee of Ministers might have on the execution of the Klima Seniorinnen judgment. But just to address the last point you made about the separation of powers, I think it's important to recall that in the eyes of the court, to begin with, the state is one entity. The court deals with, in fact, with the sole question of international legal responsibility of the state as such for compliance with its obligations under the conventions, without it being decisive which branch of power is responsible domestically. And in various cases, the court looked into the operation of all the three branches. You know that, for example, our famous process-based review is extended also to the parliaments, not only to the courts, as a matter of principle. But of course, specifically on your question, I'm of course not in a position to predict how it will then develop. Thank you.
Professeur Tridimas veut également prendre la parole encore.
Thank you very much. It's a very interesting point that you raise, although, yes, I'm not sure if it is exactly within the topic. Now, okay, an obligation to enforce a judgment depends also on what the judgment says. And when judgments impose positive obligations, and this does happen when they pertain to socioeconomic rights, it may well be necessary that the legislature will have to take action. Or the executive may have to take action which is in the form of rulemaking, in the form of adopting general rules. So I think there may well be some discretion on the part of the authorities, but the state will need to engage. The legislature would need to engage. There are examples, for example, from South Africa, where the Constitutional Court there is quite active in enforcing socioeconomic rights. And I appreciate that there are difficulties in those cases, but I think the point is that even in those cases, there has to be an engagement on the part of the national legislature or the part of the national executive within the guidelines that have been set by an international court. So I appreciate the difficulties, but the judgments, I would say, remain binding. And it is a matter of, I would say, interdependence between different institutions, and in this case, a supranational court and the national legislature. Thank you.
Alors, je me permets maintenant de reprendre la parole pour mettre un terme, clôturer ce débat. Et j'invite d'ailleurs les partis qui ont des questions peut-être de nature plus politique à les resoumettre à un panel suivant dont ça rentrera peut-être plutôt dans les compétences et dans le domaine de discussion. Maintenant, ce premier panel est clos et je vous invite à rejoindre la pause café devant la porte. Merci. Et je remercie évidemment tous les intervenants.
Oui. So Bien. Mesdames et messieurs, nous allons reprendre le cours de cette conférence. Alors, je me joins bien évidemment aux remerciements qui ont déjà été exprimés. C'est un grand plaisir pour moi que de modérer cette deuxième table ronde sur la résolution des problèmes systémiques et structurels de non-exécution des décisions nationales comme condition préalable à l'exécution des décisions de la Cour européenne. On l'a déjà vu, c'est un sujet bien évidemment fondamental, non seulement pour les individus et la protection effective de leurs droits, mais également pour le système européen dans son ensemble, puisque, comme cela a été rappelé, la non-exécution des décisions de justice interne entraîne la violation de la Convention et par ailleurs, lorsque le problème se trouve être de nature structurelle dans certains pays, il est à l'origine d'un nombre important de requêtes devant la Cour qui viennent engorger le prétoire de requêtes répétitives qui pèsent ensuite sur la capacité de la Cour à dédier ses ressources au traitement d'autres affaires tout aussi importantes. Face à ce problème, l'ensemble des acteurs étatiques doivent donc bien évidemment se mobiliser en connexion, en collaboration avec les organes du Conseil de l'Europe, le comité des ministres, bien évidemment, le service de l'exécution, mais également l'Assemblée parlementaire du Conseil de l'Europe. Alors, pour illustrer les défis et les solutions possibles pour avancer sur la voie de cette exécution, nous avons la chance d'avoir un très riche panel sur site et en ligne, avec notamment M. Pavlo Puškar, chef de division au service de l'exécution des arrêts de la Cour européenne, qui, par ailleurs, outre ses fonctions au Conseil de l'Europe, est également intervenant enseignant dans différentes universités, dont l'université de Strasbourg, et qui nous présentera de manière générale les défis de l'exécution. Madame Roxana Chiuariu, qui est juge en Roumanie, également membre de la CEPEJ à ce titre, et qui nous présentera quelques avancées réalisées en droit roumain sur le chemin de l'exécution. Monsieur Volodymyr Venner, doyen de la faculté de droit de l'Université nationale Académie Molia de Kiev, qui est en ligne, qui est également expert auprès de la Commission de Venise, ce qui explique certainement le choix de son sujet, puisqu'il nous présentera les liens entre l'état de droit et l'exécution des décisions de justice. Madame Zarina Karimova, conseillère juridique à la Cour administrative du Luxembourg, et qui nous présentera un exemple précis relatif à la nomination du commissaire spécial en cas de non-exécution des décisions de justice. Et enfin, Madame le professeur Alice Donald, qui sera avec nous en ligne, qui est spécialisée professeure de droit des droits de l'homme à l'université Middlesex, et qui nous présentera l'importance du rôle des parlements nationaux dans la question de l'exécution des décisions de justice. Comme pour le premier panel, nos intervenants disposent d'une dizaine de minutes chacun afin de pouvoir ensuite échanger avec la salle. And with no further ado, I give the floor to Mr. Pavlo Puškar.
Thank you so much for the opportunity to speak here today, and as well thanks to Luxembourgish Presidency, to the Council of Europe for support to organizing this conference, but most importantly on behalf of the Department for the Execution of Judgments to our colleagues from CEPEJ for having this collaboration together. I think it's an essential part of this exercise, and I will explain why in turn actually. I have prepared a little presentation for your kind attention, and I think what I wanted to focus on in this little presentation are three elements, actually why, what, and how. And these three elements, if you can turn to the next slide after this one, they are actually trying to explain why are we speaking about the enforcement of domestic judgments in the first place. It is such an important key problem, as you have seen from the first panel, and I think we tend to overlook this problem, focusing on more important, advanced new legal discussions. However, it is such a foundational issue that we can basically forget about the rest. Rights and judicial safeguards would be illusory or meaningless if enforcement of the domestic judgments doesn't work. The second part of what I wanted to speak about is actually how this problem revolved, or how this problem evolved in the context of both jurisprudence of the European Court of Human Rights and actually the acquis of the Committee of Ministers of the Council of Europe. And I think it is important to take a look backwards at the moment since the very first discussions by the European Court of Human Rights on the case of Hornsby. By the way, for those who teach, I think it's quite an interesting name, which is also related to the St. Patrick's Day today. It's the name of the cider at the same time, and it's the name of a town in Australia, so students easily remember this case by such references. And it's something that I would suggest to look at exponentially as to what kind of developments occurred since the judgment in Hornsby versus Greece, and whether indeed it was the first case that discussed this issue. And the third question I wanted to focus on is the question as to what kind of solutions are being offered through execution of judgments through the work of the Committee of Ministers. This might seem to be simple and self-evident as solutions, but rather frequently these solutions are being overlooked. Even though the issue of enforcement from a legal point of view, once again, as we have seen and the discussion in the first panel has shown it, is so trivial, it still represents a number of complex challenges to identify the root causes of the problem of non-execution in each and every domestic setting. While the root causes might be different, the symptoms are the same, and it is important not to mix the symptoms with the root causes in order to resolve them. Next, please. So speaking about the problem of non-execution, I think when I first encountered this problem in my professional life, I actually worked as a lawyer in a law firm dealing with a large-scale investment disputes. And speaking to my colleagues from a Western law firm coming from Ukraine, I wasn't able to explain the problem. Actually, the colleagues were not receptive to a possibility that a judgment which is final and binding, which has the force of res judicata, could not be enforced. And this was a part of a discussion on a fair and equitable treatment standard as regards the foreign investments. You can see another dimension of a potential discussion of non-enforcement of judgments being at the heart of a problem, of a legal problem. Of course, the colleagues did not believe it, and I wasn't able to find proper references for that, and that actually was occurring at the similar moment when the Hornsby case law had appeared. And indeed, this problem, once again, it presents several issues. And once I started working for the European Court of Human Rights in 2002, the first case I encountered, the case of Katsuk versus Ukraine, was quite a remarkable example of how long it takes for the state to enforce a judgment concerning domestic non-enforcement. Actually, the judgment that was adopted in 2005 was considered to be enforced by the Committee of Ministers in 2019. Basically, it took about 20 years for the domestic legal system to resolve the issue of non-enforcement. And that was quite a striking element in this discussion. Of course, today we have spoken a lot about the case of Burmic. It's not a trivial case, it's an exceptional case. The aim of this discussion is not to actually name and shame the country concerned, which faces the difficulties related to war and other difficulties relating to social affairs inside the state itself. But I think we have to name the problem and to discuss the problem in its entirety in order to identify solutions, which we are going to discuss in turn. Indeed, we have said that the problem of non-enforcement is a general problem of rule of law and access to justice. It has been identified as early as 1997, even though already in the 80s we can see that in the case law of the European Commission on Human Rights and the cases preceding the case of Hornsby, this problem was discussed from different dimensions. But it's a clearly distinct, separate issue as it appeared in the case law on Hornsby, and probably the case of Hornsby was so explicit on the refusal to abide by the final judgment of the court that it became a judgment of the European Court of Human Rights. But what we have seen since 1997 is an increase and accumulation of cases before the court and the Committee of Ministers of the Council of Europe. This accumulation was being mentioned by my colleague, Mr. Hassan Bakirci. The court has dealt with some 57,000 applications of a similar kind. If you look at the HUDOC exact database, it's very difficult to establish how many cases exactly concerned non-enforcement, even from that database. But we can see that actually from 1,300 to 1,700 cases were pending enforcement before the Committee of Ministers of the Council of Europe. What has appeared from that moment is a stronger case law, more detailed case law, based on the same principle as mentioned by Judge Gutowski, but also more detailed description of the same principle from various angles. That led to more detailed analysis of the problems related to root causes of non-enforcement, and actually stronger decisions by the Committee of Ministers calling to restore the requirements of the rule of law in various countries, including Greece. As a result of the Hornsby judgment, by the way, the Greek authorities have changed their constitution and legislation related to enforcement of judgments. So that's a direct outcome of a case through general measures that were applied. So indeed we have a better identified problem with clearly understood root causes. And I think that's something that is of importance too. Without clear identification of the root causes and underlying causes of the problem, we cannot resolve this problem. I think the example of lack of funds is quite a significant example, whereas you need to understand where such lack of funds comes from. And if you understand that this lack of funds comes from the state policy of not funding enforcement of judicial decisions, I think that's a significant problem which relates to the role of judiciary in public administration and good governance overall. It goes to the heart, as it has been discussed, of judicial independence and separation of powers, and essentially to the fact that political powers are not recognizing the right of judiciary to rule on public administration matters and finance, social affairs and budgets, suggesting that the judiciary acts ultra vires in some cases. So if we stick to the next slide, the elements I wanted to suggest are relating to the nature of these root causes. Indeed, in judgments of the court where non-enforcement lies at the heart of ECHR judgments, it is quite frequent that the judgment reveals complex problems of endemic nature. It can reveal a cluster or bouquet of problems that need to be resolved that are adjacent to the problem of non-enforcement. And indeed, in some cases, we see identification of so-called systemic and structural problems that require coherent multi-layer change that would involve changes to the legislature or to the legal framework, institutions, practical change. What is required and what is seen as the best practice in this respect is careful analysis of the root causes. And we have examples from the practice of the Committee of Ministers where strategies and action plans have succeeded, which were prepared domestically and were accepted domestically by all actors within the domestic legal system. What is required is also step-by-step steady and meticulous work on implementation of a specific judgment. Indeed, otherwise negative outcomes are rather likely to occur or the change will not happen. Coherence and steady pace are also required for elaboration of possible pilot solution, and I would like to switch to the next slide, which have been mentioned already by my colleague Hassan Bakirci, where the Committee of Ministers has suggested to pilot a specific solution for a cluster of cases or a group of cases. Then, after a test phase in implementation of these measures, expanding such solutions to the entire system. Positive change as we have witnessed from the practice of the Committee of Ministers, leads to positive results overall for the system as a whole. And that relates also to the requirements of accession to the European Union, which have been mentioned by Professor Tridimas today. Indeed, these are important elements to show that there is a steady progress on rule of law and the respective chapters of the accession agenda and Copenhagen criteria. A Committee of Ministers, in this sense, its acquis can offer a range of practical solutions that worked in practice, and we are more than willing to share these solutions with the Member States. However, as this conference already shows now, at this point, I think more is necessary to enhance and detail solutions offered for challenges. And therefore, I think the process of discussion of enhanced standards, as has been mentioned before, is very important, and we are very glad to work on this with CEPEJ and experts of CEPEJ and the CEPEJ Secretariat in this respect. Finally, as regards the conclusion, I think I tried to expand on the three questions that I have raised as to why we are speaking about enforcement of domestic judgments. The issue of non-enforcement is indeed a key foundational issue for the operation of the legal and judicial systems based on rule of law standards. Indeed, if enforcement of a res judicata judgment that is final and binding, which has legal consequences, if it's not enforced, if its enforcement is impossible, then it could lead to a situation where substantive rights under the Convention would become illusory, and not only a right of access to justice as cited in Hornsby. As to what, the question as to the problem we have discussed today, there were significant developments in the case law of the court and the CM practice since 1997 as based on the process launched by Hornsby. Indeed, the problem of non-enforcement became more explicit in the case law and CM practice as it was so much analyzed and so much analyzed with more detail. The root causes became more evident and visible for specific cases relating to the problem, both through the judgments themselves, which revealed this problem, and the Committee of Ministers supervision process. And as to how, I think that's the most important question. I think there are no magic solutions to suggest in this area, but the issue of enforcement of domestic judgments, even though it is very straightforward from a legal point of view, it represents so many layers and dimensions, as I have mentioned, of the root causes that have systemic repercussions on the domestic legal systems in each and every domestic setting. The main need in execution is not only to identify clearly these root causes and challenges, blockages that impede realization of rights for enforcement of judgments and thus access to justice. It is important also, as has been mentioned, and I fully agree with that conclusion of Hasan Bakirci, it is very important for the Court, Committee of Ministers and the national authorities to act in synchrony, to be able to clearly define the root causes and origins of the problem, but also to agree on them together, to be able to tackle it properly. We are here to assist, not to name and shame. And this discussion, indeed, I hope will bring us to some solutions that would be offered for the future. I hope I have achieved the task of at least laying the foundation for answering these questions I have asked from this discussion, and looking forward to further discussion. Thank you.
Merci, Monsieur Pushkar, pour cette introduction. Je donne immédiatement la parole à Madame Cuariu pour une présentation concernant le droit roumain. Merci beaucoup.
I will start by thanking the organizers for the invitation to participate in this event, which honors me both by the topics selected for today and through the special settings for the debate. So I will start my presentation with, can we put the PowerPoint? My presentation will explore the Romania efforts towards compliance with the European Court of Human Rights standards. So Romania used to have a negative track record of the European Court of Human Rights violations in the field of enforcement of final court judgments. The situation significantly improved after the entry into force of the new Code of Civil Procedure in 2013. The new legal framework was analyzed in Cioccodeca case, and the European Human Rights Court concluded that the current mechanism for the enforcement of judgments against private debtors includes a number of new and important safeguards. So I will continue with the presentation of the historical context. The judgment of the Cioccodeca case came after the adoption of the 2003 judgment in the Ruianu versus Romania case, when the court found a breach of Article 6.1 of the Convention due to the authorities' failure for more than 8 years to take the necessary measures to ensure the execution of a final and enforceable court judgment ordering the demolition of the building belonging to the creditor neighbors. The Ruianu case was a leading case for 18 subsequent repetitive cases in which the European Court of Human Rights adopted judgment finding similar violation of the convention. These repetitive cases were solved by the court through judgment in the period 2007-2014. After Ruianu case, general measures were implemented by our authorities, including translation and dissemination of the judgment, of course. But the most important thing was that a new legal framework for the execution proceedings was introduced in 2003. After this new framework for executing proceedings entered into force, in 2017, the Committee of Ministers adopted a final resolution closing the supervision of the execution process in the Ruianu group of cases. So I'll continue by sharing with you the most important provision that we find now in our legal framework. So now the enforcement is predictable. That is very important. So the code regulates enforcement procedures in much more detail and rigor way, imposing compliance with optimal and predictable terms in the enforcement phase. Also, we expanded the enforcement scope. So now it can be possible in Romania to have the enforcement not only for final judgment, but also in certain cases, even in non-definitive judgments, in order to protect the creditor rights. Our new procedural code also prevents the dilatory behavior of the debtors through the inadmissibility of defenses when challenging enforcement. We are talking about the defenses regarding the substance of the right. We enhance the authority support in the law, and it was introduced a legal basis for prosecutors, for police, for gendarmerie, and for other law enforcement officers to support court decisions enforcement. In our new procedural code, we have also special provision for minors. The code regulates a distinct, supple, and flexible procedure regarding enforcement in cases involving minors, in order to comply with the ruling of the European Court of Human Rights in cases against Romania. Also, our public judicial aid system in civil matters facilitate the creditor access to enforcement procedure if the creditor doesn't have the material means to pursue this procedure. We have other provisions that are really important in the law, and it's important that now the code regulates in detail the role of the bailiff, including the cases in which he or her can be changed or replaced. We have regulated also the appeal mechanism against trial delays applicable in the enforcement phase for resolution of enforcement incidents. Another improvement was the bailiff's fee transparency that is very important for the enforcement phase. So in Romania now, bailiffs cannot condition the execution of a court decision on advance of the fee, and the maximum and minimum fees are established by law by an order of a minister. So there are also sanctions that weren't in the past, but now we do have it and we do use it for the person, including bailiffs, who postpone or delay enforcement. We have sanctions also with potential criminal reporting for facts that are impairing enforcement. Now I want to talk with you about our recent developments regarding the enforcement procedure in Romania. So at the end of the last year, our Supreme Court issued a decision for the unitary interpretation of the law, determining that enforcement courts can determine not only legal interest rates, but also contractual delay damage. Therefore, the creditor will have a quicker way to enforce even the accessories of the main debt without opening a new case for the determination of such contractual delay damages. We have also in work a draft law that aims to eliminate the procedure for approving enforcement by the court when dealing with titles represented by court decisions, potentially shortening the process of enforcement. I have to say that last year in Romania we had 120,000 cases regarding the approval of enforcement. There are a lot of cases, so this draft law, the future law, will change the volume of work for judges in Romania for sure. And it will shorten the period of enforcement for titles represented by court decisions, final court decisions. And also we want to do a new bailiff law reform because it is important to improve the quality of recruitment and selection procedure for members of the profession, for bailiffs. And it's important to have a professional continuous training for them. I want to talk with you about a case. We had some discussions in Romania about a provision in the law. So in the law, the bailiff will request the declaration of execution by the court in maximum 3 days after the registration of the application of a creditor for enforcement is made in his office. So we discussed about this maximum 3-day term, and we reached to the conclusion that if this maximum 3-day term, it's not, if this term is not respected by the bailiff, we won't sanction the creditor, who will keep the right to enforcement, but the bailiff will be an object to the disciplinary measures if he doesn't respect this maximum 3-day term. So I put some images in order to see how the procedure is working in Romania. So for the beginning, we have the registration of the creditor application. After the bailiff will submit the application in 3 days. The court in 7 days will give the declaration of enforcement and will authorize the execution. And if this term of 3 days is not respected, there can be actions for disciplinary liability or possible sanction for non-compliance. But normally in Romania, the bailiff respects this 3-day term, so we didn't have a problem after we discussed this problem in the courts. And we made it public in the National Institute of Magistracy site in order to everyone to see it. And at the ending, I wanted to talk with you about the practical impacts and recent developments in Romania. So the new legal legislative mechanism that was validated by the European Court of Human Rights in the Ciocodeca case are being effectively applied in practice. So the number of complaints against bailiff refusals to enforce the court decision were reduced by more than a half in the last decade. As you can see, in 2013 we had 1,051 cases, and now in 2024 we had only 399 cases. So the challenge to enforcement has proven to be an effective remedy according to Article 13 of the Conventions. So this improvement that I already presented to you demonstrate Romania's commitment to address previous shortcomings and ensuring that we try to comply with the European Court of Human Rights standards regarding enforcement cases. Thank you.
Merci beaucoup pour cette présentation. Et donc, je donne la parole à Monsieur Venner qui nous rejoint en ligne. Un grand merci. Monsieur, vous avez la parole.
Thank you so much. I hope you can hear me, dear colleagues. First of all, thank you so much for this great opportunity to present here some thoughts on execution and enforcement of judgments from Ukrainian perspective. Representing here academia, society, and university professors, I have a little bit more freedom, not only to criticize, but also to propose some directions and some ideas how to improve Ukrainian experience and how to deliver better solutions for Ukrainian perspective right now, which is not really easy, as we all understand the circumstances in which Ukrainian society and Ukrainian authorities are supposed to work. So I would start, and here you have a short presentation which I would like to share with you. And I will start with first and really important message that rule of law elements in Ukrainian reality for the last more than almost 30 years a key priority to implement. And if you will take a look on a first slide, I hope you can see first slide. Yeah. I want to stress the key element of the procedures for enforcement of judgments is a proper national legislation and a proper national structure of legislation. And here I want to stress and to point out two problems. First one is a substantial one, and it's not about judiciary itself or Ministry of Justice or enforcement authorities. It's about the more deep perception of the legal reality in Ukraine as post-Soviet country. We still have this post-Soviet way of thinking. We still have in our constitution a very populistic or very socialistic perception of the human rights, especially in social rights protection. It's not only about pensions and different benefits, but also about labor rights and many other things. So the roots, substantial roots, are very deep in Ukrainian constitution, and as a result in parliamentary statutes, parliamentary legislation, and of course secondary legislation. This is a key problem, and reconsidering this part of the national legislation is a key priority right now, and I suppose directly after Ukraine's victory, we will have this opportunity to revise not only Chapter 2 of the Ukrainian Constitution, but Constitution itself during EU accession process. And the formulas or wording of the relevant constitutional articles are really, really important to move ahead with this, to fight with this still post-Soviet kind of thinking, not only in legislative level, but also in a judiciary. Because if you will go through the number of cases, a number of applications against Ukraine to the European Court of Human Rights, you will see that a lot of them, they are really related and have very social background and populist judgments, populist decisions of the Ukrainian parliament. It's really hard to implement for the judiciary. So first message, legislation should be revised in more general perspective, in more deep direction. And second one, it's also procedures of enforcement. Right now, we had a few attempts to restructure Ukrainian system, functioning of the Ministry of Justice, functioning of many other Ukrainian authorities in this direction. In some cases, we have huge progress, like in anti-corruption infrastructure. We have new institutions, both in pre-trial investigation and at the end of enforcement of the judgments. But this positive experience should be multiplied nationwide. At the same time, some lessons learned with some negative results. We also have some negative results should be taken into account and widespread. Next slide, please. And from this perspective, I want to stress that Ukraine, as we all know, belongs to civil law system countries, and in Ukraine, it's really crucial to follow relevant elements of the rule of law. And here I want to remind that any attempts to proceed with enforcement of judgments without taking into account a relevant level of legislative regulation could fail, because it's not enough to rely on political actors, on national stakeholders. It's really crucial to change relevant legislation at the parliamentary level. And here you can see on a slide that Article 92 of the Constitution of Ukraine defines a special nature such regulations. I can assume that it's much easier to for governmental agencies and for a cabinet of ministers to develop different new ideas and different new tools, how to measure, how to influence on some preconditions, but without following rule of law and this precondition as legal certainty, it's really hard to move on. Next slide, please. And the key point here should be Venice Commission achievements and, of course, rule of law report and the checklist. And I hope new document, which is, I suppose, on a final stage, we will have new ideas and new messages from Venice Commission in the nearest future on a rule of law. But next slide, please. Talking about the elements which should be implemented in Ukraine in a nearest future, it's of course legality and legal certainty. Without proper, I can say, audit or revision of the both constitutional and legislative background, it's impossible to reduce these harmful numbers of judgments which are not implemented in real life. Next slide, please. Of course, you can ask me and challenge to what extent Ukrainian parliament is ready for such an actions. And here we have really unique situation because in wartime, Ukrainian parliament still active, and results of the analysis of legislative and parliamentary activities, we can see that starting in May 2022, political tensions and political discussions came back to Ukrainian parliament. Parliament still working. Parliament still with a little bit limited and simplified parliamentary procedures, issuing and adopting relevant legislation. And the level of transparency is a little bit lower than before the full-scale aggression, but parliament is still working. So from my personal academic perspective, we don't have any excuses for parliamentary authorities not to proceed with such an audit or such opportunities to modify and to find the solutions on both, as I mentioned, substantial and procedural points of view. What are the priorities for this conference and for Council of Europe and our international partners to follow and to move on? This next slide. I present here statistics you are familiar with. It was my aim not to use very recent one, but to use at the beginning statistics as the beginning of full-scale aggression of September 2022. You will see that Ukrainian part of the applications to European Court is extremely high. And at the next slide, please, you will see the key challenges for Ukrainian legal system, and it's not just problems with judiciary itself, because the roots of social problems are much deeper, and they need a little bit wider perspective to analyze and to find solutions. Next slide, please. And last but not least, to conclude, from my perspective, we have key elements for further development in Ukrainian reality. First of all, lack of institutional independence in the judiciary and very often Soviet style of mentality, Soviet style of thinking of the judges, it brings to very, very harmful cases when some of the judgments it's even impossible to implement in legal reality. For example, we still have very social even socialist-oriented interpretation of the Constitution and, for example, social rights provided by the Constitution. And our judges very often, they ignore relevant case law and practice from other Council of Europe member states, constitutional courts, and these solutions are already invented. We just need to follow them, we just need to implement them in our case law, and very often a lack of institutional independence cause the fear of the judges to make new approaches, to develop new ideas, and to protect human rights in a little bit different way, especially at the level of Supreme Court and Constitutional Court. Independence of judges or preventing of corruption is not only regular bribing, it's also political influence, especially in these social protection cases and other issues where Ministry of Finance or other governmental agencies are extremely interested to balance national budget and all the expenditures from a state budget. It's really important and crucial to develop different approaches at the level of Supreme Court. Some of the cases at the previous slide, you saw that a lot of problems with criminal justice. I think the Institute of Investigating Judge in Ukraine needs to be strengthened and needs to be implemented in a more complex way, because right now, during wartime, we had attempts from Ukrainian parliament even to stop relevant judicial control on pretrial investigation. And from my perspective, all these attempts should be stopped. And moreover, Ukrainian parliament should develop new tools and ideas how to strengthen an opportunity for a judiciary to make a real effect on a pretrial investigation, especially on issues like detention and many other very vulnerable spheres of prosecutors functioning. ADR, of course, ADR in Ukraine was still on a lowest level, and legal aid system, a legal remedy. Combination of these two components could bring us to the point where enforcement of the judgments won't be a crucial thing, and rule of law will be guaranteed on a pre-judicial stage. And from this perspective, we still don't have relevant implementation at the legislative level or the relevant legislation on mediation and other ADR tools. Just to conclude, I think all these directions and priorities before Ukrainian legal system, even in wartime, even in really harmful extraordinary situation, are really possible to follow and to meet, and I hope we will have an opportunities to reach these goals. Thank you so much for inviting me. Thank you so much for an opportunity to deliver these ideas, and it's also a great opportunity for us to hear from you and to implement your experience in our legal reality too. Thank you so much.
Merci beaucoup, Monsieur le Doyen, pour cette présentation. Je donne la parole à Madame Karimova.
Je vous remercie et je remercie également tous les organisateurs de cette conférence. C'est un vrai plaisir et un honneur d'être là et de partager avec vous en fait la perspective luxembourgeoise sur la question d'exécution des jugements, plus spécifiquement dans l'ordre administratif. Alors, ce qui est important de souligner, c'est que au Luxembourg, nous n'avons pas un problème systémique d'inexécution. Donc, il existe quelques cas, mais ça reste quelque chose de très limité. Ceci dit, même si ça reste quelques cas et que c'est limité, ce sujet est quand même très, très important. Je dirais d'autant plus pour l'ordre administratif, puisque le contentieux administratif est particulier, dans le sens que c'est un contentieux qui oppose un justiciable, donc un administré, à l'administration et à toutes les émanations de l'État. Et que le justiciable est dans une position un petit peu délicate, puisque l'obligation qu'il a avant tout, c'est de s'exécuter, c'est-à-dire que il n'a pas le choix que d'exécuter dans un premier temps la décision administrative et seulement dans un deuxième temps se tourner vers le juge administratif pour éventuellement demander une annulation de l'acte qui lui fait grief ou bien la réformation de cet acte. Donc c'est pas comme, on va dire, dans le contentieux civil où la partie peut avoir le droit en fait de ne pas s'exécuter tout de suite, ou bien d'aller voir le juge et de lui demander tout de suite des dommages et intérêts pour un préjudice qu'il a subi. Donc, c'est un sujet très important puisqu'en fait, il permet de quelque part garder l'équilibre des droits et des obligations entre d'une part l'administration et d'autre part l'administré. Alors, comment ça se passe au Luxembourg ? Nous avons un mécanisme assez particulier, donc c'est celui de la nomination du commissaire spécial. Je pense qu'il existe dans quelques d'autres pays européens. Et donc, en fait, c'est un système aussi qui est assez récent, finalement, dans la législation luxembourgeoise, puisqu'il date de 1986, lorsque le législateur luxembourgeois a décidé d'introduire ce mécanisme pour s'assurer de la bonne exécution des décisions de justice. Donc, c'est assez intéressant de lire les travaux parlementaires de cette loi, puisque le législateur luxembourgeois s'est demandé s'il ne va pas s'inspirer de ses voisins, notamment la France et les Pays-Bas, pour trouver des solutions à la problématique d'inexécution et de donner les droits aux juges, comme par exemple les droits d'astreinte, de prononcer des astreintes, ou le droit de prononcer des dommages et intérêts, comme c'est le cas en France et aux Pays-Bas. Et puis finalement, c'est le système du commissaire spécial qui a été retenu, puisqu'il existait déjà dans le droit luxembourgeois, et plus particulièrement dans le droit des communes, en fait, puisqu'en fait, lorsqu'une commune refusait de s'exécuter, son ministre de tutelle avait le droit de nommer un commissaire spécial qui venait et qui donc prenait toutes les mesures nécessaires en lieu et place de la commune. Donc c'est un système qui paraît tout à fait simple. Lorsqu'un justiciable, lorsqu'un administré obtient une décision de la justice et qu'il constate que l'administration ne s'exécute pas, il peut revenir voir le juge qui a déjà décidé la première fois son affaire et lui demander de nommer un commissaire spécial. Ce commissaire spécial va donc se substituer à l'administration défaillante et exécuter la décision de justice, donc le jugement par exemple qui a été prononcé. Donc en théorie c'est tout à fait simple, mais en pratique c'est un petit peu plus compliqué parce que la jurisprudence, la manière dont elle s'est saisie de ce mécanisme, elle a réduit de manière assez drastique les possibilités et les cas d'ouverture de la nomination du commissaire spécial. Pourquoi ? Parce qu'en fait, le juge se contente simplement, en tout cas dans la jurisprudence jusqu'à un arrêt très récent en 2024, le juge se contentait simplement de venir vérifier si l'administration a effectivement pris une décision. Le juge ne regardait pas quelle était cette décision, est-ce qu'elle se conformait bel et bien avec le jugement qui a été prononcé, est-ce qu'elle l'exécutait de manière exhaustive et non pas parcellaire. Toutes ces questions étaient mises de côté. Le juge constatait qu'il y a effectivement une décision qui a été prise par l'administration, y compris si cette décision a été prise en cours d'instance, c'est-à-dire lorsque l'administré a déjà déposé une requête pour la nomination du commissaire spécial, et constater qu'en fait, il n'y avait plus lieu de nommer un commissaire spécial puisque l'administration a pris une décision. Et dans ces cas-là, qu'est-ce qui se passait ? C'est que l'administré n'avait d'autre solution que de retourner à nouveau voir le juge, cette fois contre cette dernière décision, et donc d'intenter un nouveau recours. Pour vous donner un exemple un petit peu plus concret, donc il y a un administré avait demandé l'annulation du refus de permis de construire qui lui a été délivré par le bourgmestre de sa commune. Le juge a accédé à sa demande, a annulé ce refus en fait, du permis de construire. C'était un refus implicite, c'est-à-dire que le bourgmestre a omis tout simplement de se prononcer et donc le silence vaut refus. Donc le justiciable a effectivement obtenu l'annulation de ce refus implicite, sauf que le bourgmestre ne s'est toujours pas manifesté, n'a toujours pas pris une autre décision suite à la décision du juge administratif. Le justiciable est retourné voir le juge administratif avec sa demande de la nomination du commissaire spécial. Entre-temps, le bourgmestre a émis une nouvelle décision, cette fois une décision explicite de refus. Le juge a constaté qu'il y avait effectivement une nouvelle décision qui a été prise et donc a tout simplement déclaré sa requête vide et donc qu'il n'y avait plus lieu de nommer un commissaire spécial. Donc c'est un mécanisme qui était extrêmement limité. Et donc le constat qui s'imposait, c'est qu'il y a un certain nombre de principes quand même qui pouvaient être heurtés par cette pratique, notamment le principe de l'autorité de la chose jugée, puisque le justiciable, alors même qu'il avait une décision coulée en la force de chose jugée, devait à nouveau intenter un recours devant le juge pour obtenir satisfaction. Et il faut dire qu'il y a eu une évolution assez récente de la cour d'appel du Luxembourg qui, à différentes reprises et dans différents cas, insistait très fortement sur cette obligation du respect de l'autorité de la chose jugée, l'obligation du respect aussi donc, de l'état de droit et donc des exécutions des décisions de justice. Et donc c'est dans ce cadre-là que s'inscrit une évolution jurisprudentielle qu'on peut appeler tout à fait bienvenue et qui est assez récente, donc celle du 30 janvier 2024, où le juge, pour la première fois, a décidé de regarder si l'administration a bien exécuté la décision de justice et si elle l'a exécutée de manière complète. Et dans ce cas-là, en fait, c'était un justiciable, c'était un contribuable, donc dans ce cas précis, qui a obtenu gain de cause devant le tribunal administratif contre le fisc, en fait, de l'administration fiscale. L'administration fiscale a pris acte donc de cette décision de justice, l'a exécutée, mais elle l'a exécutée de manière partielle. Donc le contribuable est retourné devant le juge, a demandé la nomination du commissaire spécial. Cette nomination lui a été refusée puisque le tribunal a constaté que malgré tout, l'administration fiscale a déjà pris une décision. Il a fait appel de cette décision et donc cette affaire est arrivée devant la cour d'appel. Et la cour d'appel a considéré qu'effectivement, l'administration fiscale a pris une décision, mais celle-là était parcellaire et donc n'a pas tiré toutes les conclusions qui s'imposaient suite à la décision du tribunal administratif et a donc accédé à la demande du contribuable de nommer un commissaire spécial. Elle a toutefois laissé quand même un petit peu de temps à l'administration fiscale de s'exécuter parce qu'en fait, le recours au commissaire spécial doit être un recours vraiment ultime si plus rien ne peut être fait contre l'administration, on va dire, récalcitrante. Donc dans ce cas-là précis, l'administration fiscale s'est exécutée assez rapidement et donc il n'y avait pas lieu de nommer un commissaire spécial. Alors, donc ça c'était une avancée assez intéressante de la jurisprudence récente, mais suite à cet arrêt, il y a eu un deuxième arrêt en fait dans une autre affaire dans laquelle la Cour a apporté, on va dire, une nouvelle limite en fait à ce mécanisme, c'est celle du double degré de juridiction pour la demande de nomination du commissaire spécial. Donc la Cour a estimé qu'en fait, tel que la loi est rédigée et tel que c'est prévu, le justiciable peut venir demander la nomination du commissaire spécial uniquement devant le juge dont la décision n'a pas été exécutée par l'administration. Et une fois que le juge s'est prononcé sur la question s'il y avait lieu de nommer un commissaire spécial ou pas, eh bien, le justiciable n'a plus la possibilité de faire appel de cette décision si jamais le juge décide qu'il n'y a pas lieu de nommer le commissaire spécial. Et donc en fait, ça se termine là. Donc, si le juge n'accède pas à sa demande de nomination, il n'a pas d'autre recours. et il ne peut que, encore une fois, revenir devant le juge et faire un recours devant la dernière décision de l'administration. Donc voilà un petit peu le portrait du problème tel qu'il se pose à Luxembourg.
Merci beaucoup pour cette présentation. Last but not least, I give now the floor to Professor Alice Donald from Middlesex University. Thank you.
Thank you so much. It's a real honour to be here with my fellow panellists. I also have a short presentation to share. Thank you. And my presentation will really just is in two parts. So one is some general observations and research findings about the role of national parliaments in the implementation of judgments generally, and then, of course, a few specific observations about the role of parliaments in relation to judgments concerning better enforcement of national decisions. And you'll see that I've entitled it The Indispensable Role of Parliaments. And indeed, my fellow panellists have already made this point for me, really, as we've seen compelling examples of what can happen when parliaments do fulfil that role, as in Romania, as well as when there have been problems, albeit very understandable problems, such as in Ukraine. So if we could move on to the next slide. My point here really echoes a point made by Pavlo Puškar at the beginning of our panel when he talked about different institutional actors acting in symphony. So I've chosen a slightly different metaphor here, not a musical symphony, but a web, perhaps even an ecosystem. And I think this reflects scholarship and indeed practice at the Council of Europe, which has very much come to the fore in the last decade or so, whereby even though it is the government which of course represents the state before both the court and the Committee of Ministers, nevertheless the convention system must be understood both at national level and also in the relationship between national actors and those in Strasbourg as something much more complex. I've called it here a web of interaction and interdependence between these actors who have different functions, different powers, different expertise, and also different claims to legitimacy, to the extent that the democratic legitimacy of human rights judgments is important. So no one of these actors, not the executive alone, nor any other actor alone, can secure the objective of the convention, but only through their interrelationships, which may be at times collaborative, may require coordination, may be perhaps more to do with scrutiny and oversight. So moving on to the next slide, I've pointed out here some of the benefits, particularly of having robust standing parliamentary mechanisms. And again, this is something that I think has come much more to the fore, not least because of the useful work of the Parliamentary Assembly of the Council of Europe, that clearly, as with the judgments that we're talking about today, there are times when only a change in the law or a new law is a solution, or at least is part of the solution, hence the indispensability of parliamentary action, but also that ongoing role of oversight and scrutiny that legislatures perform or should perform, that not least also the work that parliamentary bodies, perhaps parliamentary human rights committees, do in bringing to the fore, giving a voice, a platform to civil society actors, NGOs, academics, etc., and a place where evidence can be put into the public realm, and indeed the role of parliaments in creating a legislative framework, not just in relation to specific judgments, but for the implementation process generally. There are certain Council of Europe countries where the implementation of European court judgments and sometimes also decisions of UN treaty bodies is itself regulated through legislation with clear delineations of powers, responsibilities, etc. If you could just click again to the bottom of this slide. I've mentioned here the importance of democratic deliberation of the implementation process following a Strasbourg judgment being seen to be democratically legitimate. I think that in relation to our topic today, this is not something which is so problematic. These judgments are not generally seen as, an imposition upon the domestic system. It is generally acknowledged if there is a systemic problem of this kind. But this, of course, is very important in more politically explosive or contentious cases, such as these days cases concerning immigration matters, for example. So that important strand, therefore, of parliamentary work is conferring democratic legitimacy on the implementation that follows after a European Court judgment. Moving on. I've shown here a handbook that I was lucky enough to co-author with my co-author Anne Speck a few years ago for the Parliamentary Assembly, which is really aimed at national parliamentarians, and it just sets out here some of the obvious functions of parliamentary human rights bodies in terms of scrutiny of draft legislation, legislating, of course, to give effect to judgments, monitoring systematically the executive's record in this regard, and also other things which are perhaps less often thought about, such as parliamentary involvement in the drafting and ratification of international human rights treaties, and conducting thematic inquiries, which of course could focus on a systemic problem such as that we're discussing today. Moving on, there are also important ways in which the executive can and should facilitate this role of legislative or parliamentary scrutiny. For example, when draft legislation is brought to Parliament, as happens in the UK, attaching a memorandum to it to explain how it complies with the international human rights obligations, including those under the Convention, reporting regularly to Parliament on the implementation of judgments, something which I am not aware actually happens at least regularly in any state, but which I will continue to recommend, which is for executives to share action plans and reports with Parliament as kind of living documents during the implementation process, as well as summaries or translations of pertinent court judgments. And then involving parliamentarians in any working group created to coordinate the implementation of judgments. I'll come back to that in a minute, which may be generalised standing bodies, or they may be also convened working groups for ad hoc specific judgments. Moving on, please. This is just a snapshot, of course, of the different models of parliamentary human rights work that exist, either the specialised human rights committee or subcommittee, for example, such as we have in the UK, sometimes a more hybrid system where parliamentary work is divided across perhaps two different committees, and then countries like the Netherlands where there is no specialised committee but where human rights scrutiny is more cross-cutting. On the next slide, we can see very quickly just some of the sort of obvious pros and cons of these different approaches. The Parliamentary Assembly has been very careful, of course, not to prescribe any specific model for states, recognising the diversity of states across the Council of Europe. The obvious benefits of having a specialised committee of some kind are that development of expertise, of institutional memory, of having a kind of single interlocutor with other bodies, including the Council of Europe itself, the building of expertise. But the concomitant risk, though, of also creating a kind of silo within Parliament, this I think certainly is a problem in the UK. You have a very well-functioning Human Rights Committee, but human rights issues are not then brought to the fore in other committees. But of course, the danger of a cross-cutting model is that, to coin the phrase, if it's everybody's responsibility, then it's nobody's responsibility. So I think it's probably true to say that in countries where executive coordination is weak or parliamentary human rights work is at a low base, that generally the formation of a specialised committee, although not a panacea, is probably the preferable model. Just quickly moving on to the next slide. I mentioned the fact that a few states, a very few, as you can see them on the slide here, have created standing committees generally convened by the government agent or other executive coordination authority, which includes people from government, from parliament, from the senior judiciary, and sometimes also national human rights institutions, NGOs, academics, civil society representatives. These are only in a few states and sometimes of relatively recent origin, so it's perhaps a sort of work in progress to identify the benefits or otherwise of this model. But it does seem to be the case that where you have a standing committee of representatives who are responsible for implementing judgments, which tend to meet at least annually and sometimes more frequently in subgroups, that there are benefits of building again continuity and expertise and a shared sense of ownership and responsibility for implementation. I think also where you have very complex multi-layered judgments such as those that we're discussing today, simply that facilitation of contact between arms of the state and indeed the ability to bring civil society expertise in can be invaluable and can speed the process up. At the same time, seeing problems sort of coming down the road, so performing a preventative as well as a remedial function, and overcoming challenges and facilitating the design of reforms in response to a judgment which are both feasible and sustainable, particularly in the kind of complex multi-layered cases we're discussing today, and also in cases which may be relatively straightforward to implement, sort of logistically, as it were, but which are politically contentious. So I think that the benefit of this model can be seen in those two different types of cases. Just moving on to make a few final observations, coming back to our topic of today. And I've picked out here some recommendations from documents which were very helpfully set out in the background documentation for this event, the background paper. So both the Committee of Ministers' recommendation on the enforcement of domestic decisions and the CEPEJ guidelines. Again, my fellow panellists have already made this point for me, really, but what is so clear, and this came out from the compelling example we saw from Romania, is the need, of course, for a clear legislative framework with conferring legal certainty, transparency on the process, clear definitions of terms, etc. So clearly Parliament has a strong duty in that respect. Moving on to the next slide, the court, of course, has made it clear that in general, a preventative approach is better than a purely compensatory one. And again, you can see here from the CM's Guide to Good Practice in respect of domestic remedies, the indispensable role of Parliament in creating the legislative framework that underpins everything. Also, in almost invariably, I would say, in allocating budgetary resources to cover actual or potential state liabilities, developing, again, as we saw in Romania, the state's obligation in more detail, including through coercive or disciplinary type measures, strengthening the bailiff system again, as we've already seen. So in all of these aspects, Parliament, of course, will need to play its part, or to have played its part, in the finding these remedies to these complex problems. And then just a couple of very brief observations to follow. The next slide. Sorry about the amount of information here. This is drawn from a piece of research I've done with my colleague, Professor Philip Leach, on pilot judgments and their implementation. So we looked at all pilot judgments, but I've picked out here some of the ones on non-enforcement of domestic decisions. Of course, we've already mentioned some of these today. Again, you can see in Burdov and then much later Gerasimov against Russia, the creation of legislation to provide a remedy to the issue there. Likewise, in Moldova, For reasons I'm not quite sure, I think the Committee of Ministers is still monitoring the implementation there of the law that was adopted in Moldova in response to Olaru. I won't mention Ivanov again. We've already heard from Professor Venner. I suppose one thing that comes out here is the need also for parliaments not to place obstacles in the way of implementation in the form of moratoriums, which have indeed blocked the enforcement of judgments. And then my final slide, just a couple of observations on this table, that legislative action, of course, is, as we keep saying, invariably required for these judgments. One notable point from our work on pilot judgments is that the deadlines, which of course are set under the pilot judgment procedure for implementation, have very rarely been met, which might suggest, and we've discussed this somewhat, whether they are in fact unrealistic in setting the time frame. But in fact, they were quite often almost met, which suggests that the setting of deadlines through the pilot judgment procedure has in fact succeeded in having a kind of galvanising effect on parliaments. And it's notable that with the exception of Olaru and others versus Moldova, that actually when the pilot judgment procedure was instigated by the court, the relevant governments disputed that the problem was in fact systemic and resisted the application of the procedure, which perhaps tells us something about the sort of entrenched nature of this problem. But I will leave it there. I hope I haven't exceeded my time, and thank you again for the very valuable opportunity to join this panel. Thank you.
Thank you very much to all our panelists. Il est maintenant temps de donner la parole à la salle. Si je peux simplement vous demander de vous présenter avant de poser votre question, et si possible de préciser à quel contributeur vous souhaitez la poser. Merci.
Thank you. My first question is about the assessment of reasonable time. In the light of principles established by the ECHR case law and, of course, the practice of Committee of Ministers, how does the reasonable time in enforcement cases assessed where delays stem from structural inefficiencies, for example, that are beyond judicial control? And my second question regards Romanian practice. Are there any available incentive or bonus systems intended for the activities of compulsory enforcement officials that would promote to the proper enforcement of judicial act within a reasonable time period?
Thank you so much. As regards the length of proceedings and assessment of how the court assesses actually the length of enforcement, you see there is quite extensive case law actually recognizing that the right to enforcement is considered to be a part of overall length of the proceedings. But there are some specific cases, and this would be reflected, by the way, there are many questions in the chat concerning the background paper that will be distributed after the conference once it's finalized with the citations of the case law. And detailed explanations as to this issue as well. So the case law of the court basically speaks about the same criteria that are being applied to examination of length of enforcement as to general reasonable length of proceedings. And there are specific cases that have been examined by the court where, for instance, an element of what is at stake for the applicant from the point of urgency of enforcement proceedings, it's taken into account actually in assessment of overall length of enforcement. There is case law which is very extensive on what is tolerated by the court as regards the length of enforcement and what is not. What kind of limits are there? The grace period for enforcement, so-called grace period, which is used as a technicality and jargon by the court, how much time is allowed for enforcement of judgments, and it varies depending on the circumstances from 12 to 18 months. But the special urgency and what is at stake for the applicant is indeed taken into account, and that relates also to execution of these judgments with the same kind of findings, that the domestic systems should allow for more expedient enforcement and priority enforcement in certain circumstances as well.
Hello. So in Romania, there are no benefits for the debtor who voluntarily executes the court decisions, but for sure, if he agrees to voluntarily execute the one decision, the final decision, he won't pay the fees for the execution that are quite high in Romania. And also, he won't pay the legal interest rate that is imposed by law. So many of them executes voluntarily, but there are not any compensations or benefits for the person who agreed to execute the final decision, judgment in proceedings. But for sure, there are in administrative cases. It's a special type of cases. There are some provision when they agrees to execute some debts involving taxes or something. But they're special. In general proceedings, we don't have any compensation or benefits.
Thank you. Do we have another question from the room? Yes, please.
Commission. My question is for Mr. Pushkar. It is in relation to the role and working of the Committee of Ministers, and my query is, when a case is downgraded in good faith and with the best of intention, but the state still doesn't deliver, what options are open to national human rights organisations or to the court in terms of getting it increased to enhanced procedure again, or having it reviewed at a proper level? And then my second question is, how are cases removed from the supervision list, and who is informed, and is there an appeal process in place?
Can you switch your microphone off, please?
Thank you so much for this question. Indeed, we have this so-called twin-track procedure of supervision or examination of cases by the Committee of Ministers, whereas enhanced procedure is followed by the Committee of Ministers itself. Quite frequently, largely, the standard procedure is followed by the Department for the Execution of Judgments through bilateral exchanges with the government concerned. If indeed the civil society and NGOs or national human rights institutions, bar associations consider that the measures effectuated by the state concerned have not been sufficient, and they raise a larger issue of enforcement, they are allowed, of course, to comment on this issue through the Rule 9 procedure, which is available for access to the applicants, NGOs, and the national human rights institutions, as well as bar associations. One has indeed to provide arguments as to why would these subjects of referral of Rule 9 be considering that the case should not be pending in standard procedure but should be pending in enhanced. Now, speaking about the standard and enhanced procedure, in a sense, the legal obligation under Article 46 of the Convention is the same for cases in standard procedure or enhanced procedure of supervision. So it's rather that there is more guidance probably is sought from the Committee of Ministers on a particular execution matter. And from this point of view, the Committee of Ministers is very much guided by the similarity of treatment of similar cases. So consistency of its case law, acquis of the Committee of Ministers, if I may say so. So indeed, that's a subject for consideration for those that consider that the case should be pending in enhanced rather than in standard. But again, I would underline that the obligation to comply under Article 46 is the same. And speaking about the second part of the question as to when would the Committee of Ministers close supervision over implementation of a judgment, once the judgment is fully and adequately complied with. And that concerns three elements. Largely we are driven by the 2001 articles on responsibility of states for international wrongful acts, and the acquis of the Committee of Ministers itself. There are three elements that are considered from the point of view of full implementation of judgments, and these are restitutio in integrum, cessation of ongoing breaches, and non-repetition of similar breaches in the future. So if you take any particular case that relates to non-enforcement, this might relate to a situation, and this has been done before by the court itself, where in the operative part of the judgment, the court prescribes the state certain action to enforce this judgment, and then to pay just satisfaction to the applicant to remedy the individual negative effects of the human rights breach. The continuous nature of breaches is also considered, so cessation is a demand that comes as regards execution that is still pending or that is still outstanding. And the general measures we have discussed today, basically non-repetition, are the legislative framework work of the courts, which we have discussed today, the administrative and practical measures that have to be taken under the judgments.
Thank you. Maybe we can take some questions from the chat. So maybe, Pablo, if you can read them.
Yes, there are two questions that have been asked. Actually, one relates to the previous panel. It's a question as to whether the international financial institutions and for instance, the reference is made to the international, the European Union, the World Bank, and others can assist countries in financing the enforcement of judicial decisions, particularly in systemic cases. That's the first question. And the second question relates to the reform of the legal aid system. I think it's a question concerning Ukraine largely. It doesn't relate to execution of judgments, but maybe the panelists would wish to comment on that as well.
So as to the first question, I do not know who can answer. Can anyone? Well, we can say that I think it was mentioned that execution of judgments at the ECHR level and domestic level is in any case a main concern for the EU that was mentioned, and this is also included in the rule of law chapter of negotiations for accession to the EU, and we mentioned as well this conditionality mechanism when it comes to members of the EU, but it's not so much about help that it is about sanctions. So it's a different perspectives. But as to the second, Mr. Werner maybe can answer about the legal aid reform in Ukraine. Not online anymore?
If I may only comment on the first question, just quickly, once Volodymyr has signed in, actually, in context of Burmich judgment that we are discussing in execution measures, there is a call on the Ukrainian authorities to collaborate with the international organizations such as World Bank and the International Monetary Fund, as well as the European Union, to seek assistance for the general measures under the Burmich judgment.
Thank you for the question and for the interest. Yes, the reform is ongoing, and we have a lot of achievements in that direction, and especially free legal aid system developed by the Ministry of Justice for a few decades, for the last few decades. It's really impressive for a post-Soviet country. But at the same time, we have new challenges caused by the war. And in a war, as an extraordinary time, we can measure what is really essential and what is a little bit synthetic. So I think we have to restructure some of the ideas. We have to restructure some of the already received achievements. And of course, the key problem right now is funding for legal aid system. But right now, it's very good, especially free legal aid. Talking about legal profession and for example, attorneys functioning, attorneys institution and self-government functioning, we still have these problems, and it's more institutional problem, and we need to do something. It started in 2016, directly after amendments to the Constitution of Ukraine, and it was one of the elements to introduce, for example, monopoly for attorneys to participate in the court proceedings. So yes, it's ongoing. I hope it will be finalized in a few years, and wartime challenges only highlight some of the weak or like weakened problems, and I hope it will be restructured in the nearest years.
Thank you very much. Maybe one final question from the room. Yes, please, ma'am.
Yes, hello everyone. My name is Angela. I'm a trainee at the European Court of Human Rights. So my question is to Professor Venner. In this case, we have some compensation claims that arising from the damage caused to Ukrainian people as a consequence of the war. So my question is, how do you think they will be enforced at the national level? Because, at the Council of Europe, we have the first step. There is the register of damage for Ukrainian people. But at the national level, do you think they will be enforced, for example, taking Russian assets frozen in Ukraine, or in which way? Thank you.
Yes, thank you so much for the question. It's really huge and impressive wave of problems caused by war crimes and war crimes investigation and aggression itself. Right now, almost all national activities are concentrated on a national level. So our Prosecutors General Office and Ministry of Justice and other authorities are collecting all the evidence and all the evidence for damage. And right now, Ukrainian state predominantly pays for all the damage. For example, damage for private property, especially residential buildings, residential apartments, etc., etc. Everything is paid from state-owned sources. For a future, from my perspective, we can see two possible directions. One, it's very traditional for international law. It could be reparations. And the second one is, of course, any other sources of Russian-owned activities. Actives, but everything will depend on a peace agreement or other conditions. So it's more on an international law perspective, not really national one. But right now, I think the key problem for further or for future enforcement of such judgments is to have judicial establishment of relevant legal facts, judicial control and overview of the pre-trial investigation activities, because it's not just occasional cases. It's thousands and sometimes hundreds of thousands cases which are relevantly prosecuted according to the national legislation, and damage is counted not in all cases. So on national level, we will do whatever we can, but on international level, I think everything will depend on future results of the peace negotiations.
Merci. Eh bien, il me revient maintenant de conclure en remerciant l'ensemble de nos participants ce matin, en vous informant donc que vous êtes libre pour le déjeuner. Il n'y a rien de prévu, donc chacun est libre de trouver les ressources nécessaires comme il l'entend. Et j'attire votre attention sur le fait que nous reprendrons nos débats à 14h30 avec le troisième panel. Merci beaucoup et rendez-vous à 14h30.